Yeah, we're doing some camps this summer. The kids and my wife are going to be in Texas for a week, where
Oh,
she's
that's
from.
neat.
So, there'll be family, and then we have like a beach week planned. So
Where are you going?
we're going to Hilton Head.
Yeah, that's where we're going.
Oh yeah,
Yeah,
good.
when are you going?
We're going in July.
So are we.
Yeah.
Yeah, over not the very last week, I guess, cuts right into August, but the weekend right before that.
Yeah,
Like
that's
the
actually.
23rd through the
I
27th.
think that's when we're going as well.
That's funny.
Yeah.
We're staying at the Hilton.
Are you okay?
So,
Yeah,
oh, that's funny.
we're staying somewhere new. We're going down to
Okay, you understand.
Harbor. Harbor Pines.
Yeah.
I think that's what it's called. You know the
Harbor
area,
Pines.
not Harbor
Yeah,
Pines.
there's-
What it's called? It's the area that has the lighthouse.
Yeah, well, that's the harbor.
Oh,
And
yeah,
that's,
right.
I don't know if it's called Harbor Inn, but there is a golf course there.
Good morning. Welcome to Employment Law 101, Classifying Workers. My name's Dan Hart. I'm an attorney at Paul Hastings, Janofsky & Walker in Atlanta. I'd like to thank the Georgia Legal Services for hosting this presentation today. Before we get started on the substance of our topic today, I'd like to give a plug to the Pro Bono Partnership of Atlanta. If you'll turn to slide 1 in the PowerPoint presentation, you'll see some information about the Pro Bono Partnership. The mission of the Pro Bono Partnership is to provide free legal assistance to community-based nonprofits that serve low-income or disadvantaged individuals. The organization matches eligible organizations with volunteer lawyers from various law firms in Atlanta. And you can see on slide 3 some additional information about the eligibility to participate in the Pro Bono Partnerships programs. I also want to note that today's information that's being presented is not specific legal advice, but rather general information. If you need any specific legal advice, please do contact the Pro Bono Partnership of Atlanta, and assuming that your organization is eligible to participate in the programs, they can match you up with a volunteer lawyer who can provide specific legal advice. Our topic today is classifying workers. And although this topic involves several areas of employment law, one of the major areas of the law that's implicated by this topic is the area of wage and hour laws. These are laws that govern how many hours an employee can work per week or per day before they are required to be paid overtime. There are also laws that mandate or govern how much you have to pay employees as minimum wage. There's a substantial body of law that governs these types of issues. The major federal law that governs wage and hour issues is the Fair Labor Standards Act, or the FLSA. That's a statute that is governed and regulated primarily by the U.S. Department of Labor. You should also be aware that there are various state laws that govern wage and hour issues. There aren't a whole lot here in Georgia, but there are some, and you will certainly want to be familiar with whatever those particular laws are in your local jurisdiction, whether that's in Georgia or if you are in another state, whatever the state law is there. When determining employee classifications under the FLSA and other statutes, there are really two threshold issues that nonprofits should consider. The first issue is, are your independent contractors truly independent contractors, or are they really employees under various laws? The second threshold question is, are your volunteers truly volunteers, or are they employees under various laws? And we're going to talk about those two topics today. If you determine that the answer to either of those questions is yes, that your independent contractors are actually employees, or that your volunteers are actually employees, then you need to secondarily determine how you need to pay those workers. Do you have to pay them overtime, or are they the types of workers who are exempt from the requirements of the Fair Labor Standards Act that you pay them overtime? These secondary questions are topics that are going to be discussed next month. My colleagues Wayman Johnson and Erica Leonard are going to address this in the Employment Law 102 webinar, which is scheduled for June 16th, so please stay tuned for that. But today we're going to focus on these initial threshold questions. Are my volunteers actually volunteers, and are my independent contractors actually independent contractors? Before we go into these topics in more depth, I'd like to go over a few of the case studies that you'll have in your written materials, just so that we can get our hands around the types of scenarios that are likely to come up in your organization. If you'll turn to slide 6, this is our first case study about Tim. Tim's a licensed clinical psychologist who has presented hundreds of seminars for a nonprofit organization over the course of several years. The nonprofit pays Tim a stipend for the seminars that he provides, but it does not withhold taxes from the stipend. It does not pay Tim overtime, and it doesn't provide Tim with benefits. After the nonprofit severs its relationship with Tim, Tim sues the nonprofit, seeking benefits and overtime compensation. The nonprofit argues that Tim's an independent contractor. He's not entitled to benefits or overtime wages. And so the question is here, is Tim an independent contractor? We're going to revisit this scenario later on this morning, but this is an initial scenario that we should consider at this point. Second case study, slide 7, involves Marcy. Marcy volunteers to assist a nonprofit in grant writing. A few months later, the nonprofit obtains a state grant to provide parenting classes. The nonprofit hires Marcy to teach the parenting classes with the expectation that it will pay Marcy with the funds that it receives through the grant. After the nonprofit terminates Marcy's employment, Marcy sues, alleging that she should have been paid both for the parenting classes and for the grant writing. The nonprofit argues that although Marcy is an employee with respect to the teaching, she's a volunteer with respect to the grant writing, and that she had no expectation of compensation. Is Marcy truly a volunteer? Our third case study, slide 7, involves Julie. Julie's an administrative assistant for a nonprofit organization that provides after-school programs for children. Julie's husband, Mike, is a counselor who supervises the children during the after-school programs. This particular nonprofit sponsors a Saturday field trip to a professional baseball game. Since Mike and Julie are big Braves fans, they decide that they would like to volunteer to take the kids to this program on a Saturday, which is typically their day off. Can this nonprofit permit Julie and Mike to volunteer their time to chaperone these children to this baseball game on a Saturday? Or are they required to pay Mike and Julie for the time that they're spending doing this activity? You'll remember I said a few minutes ago that we're going to look at 2 threshold questions this morning. And the first threshold question is whether your independent contractors truly are independent contractors or whether they actually are employees. Determining whether a worker is an employee or an independent contractor is a very important decision to make. And if it's made improperly, it can be a very costly decision for your organization. Misclassifying an employee as an independent contractor can result in significant exposure under various statutes. There's not one single test under every particular statute for determining whether a worker is an independent contractor or an employee. But the key issue is determining whether the organization retains the contains the right to control the means and manner by which the work is performed. Now, why is it important whether you classify your workers as independent contractors or as employees? Well, it's important because your legal obligations to your workers are going to be different depending on whether they're independent contractors or employees. And if you'll turn to slide 10 in the PowerPoint program, you'll see some of the key differences between employees and independent contractors. Employees are protected by the FLSA, which governs or has minimum wage requirements and overtime requirements. And so if your worker is an employee, generally you're required to pay that worker at least a minimum wage, and unless the worker is exempt from the FLSA, you have to pay them overtime if they work more than 40 hours in a single work week. In contrast, independent contractors are not protected by the FLSA. There are no minimum wage or overtime rules that govern those particular workers. Employees generally receive benefits. If your organization provides health benefits or other benefits to its workers, the employees are entitled to participate in those programs. Generally, independent contractors are not eligible to participate in those types of benefit programs. Employees are protected by a number of anti-discrimination statutes, like Title VII, which is a statute that prohibits employers from discriminating against employees on the basis of race, sex, national origin, and a host of other things. In contrast, the anti-discrimination statutes generally do not cover independent contractors. Your employees are potentially eligible for unemployment benefits. If they lose their employment involuntarily, they can apply for unemployment benefits to the state unemployment benefit office, and in most situations they're going to be eligible to get those benefits. And you're also required to pay taxes on the wages of those workers that will go towards the unemployment benefits program. In contrast, independent contractors are not covered by unemployment benefit programs. They're not eligible to receive benefits after their work ends with your organization, and you're not required to pay taxes for unemployment purposes on their wages. Finally, employees are subject to withholding for federal income tax, and you are required by IRS rules to report their wages on a W-2 form. In contrast, independent contractors do not have their payment reported on a W-2 form, but on a 1099, and you are not required to withhold for tax purposes from the payments that you give to them. So there are a host of different obligations that you have under a number of different statutes, depending on whether your workers are independent contractors or are employees. There's no one test to determine if workers are independent contractors or are employees. However, there are a variety of situations in which courts use a test known as the common law test to determine whether workers are independent contractors or are employees. By common law, we're referring to a body of law developed over hundreds of years by judges as opposed to statutes that are passed by legislatures. A lot of times these rules were developed over hundreds of years by judges going back to England even before the American Revolution. And there's not any particular single test that's used, the common law test, but there are various versions of it, and some are more commonly used than others. A lot of times statutes that apply to employees will not define the term employee very helpfully. Sometimes they'll say things like an employee is anybody employed by an employer, and that's obviously not a helpful definition. And so what the courts do is they look at this common law test, this body of law developed over hundreds of years by the courts, to try to plug in the holes in the statutes to determine whether a worker is actually an employee subject to the statute or whether they're independent contractors who are not subject to the statute. As I said, there's not a single version of this test. There's different versions of it. But the most common version of it is a version of the test used by the United States Supreme Court in a case called Nationwide Mutual Insurance versus Darden. And the Supreme Court looks at a number of different factors to determine if a worker is in fact an independent contractor or is actually an employee. If you'll turn to slide 11, these factors are listed. The first factor is the skill required. If the worker is doing some type of project that requires a significant amount of special skills, it's more likely that that particular worker is an independent contractor. Conversely, if the worker is doing a job that doesn't require any type of specialized skill, it's more likely the case that that worker is in fact an employee. To use a real basic example, if your organization were to hire a contractor to build a building for your organization or to renovate a building, nobody would assume that that particular contractor is in fact an employee. The person's doing a very highly skilled job building a building or renovating a building for your organization. In contrast, if you are retaining individuals to do basic tasks, digging ditches or something like that that doesn't require any particular level of skill, it's much more likely the case that those particular workers are your employees and not independent contractors. Another factor is the source of the instrumentalities and tools that are used by the worker. If the worker is providing the own tools that they use, whether that's a computer or those are different types of machinery or shovels, that sort of thing, it's more likely the case that that particular worker is in fact an independent contractor. Conversely, if you as the organization are providing the tools that that worker uses, it's more likely the case that that worker is an employee. A third factor is the location of the work. In most scenarios depending, regardless of whether the worker is an independent contractor or an employee, they're probably going to be working at your organization's facilities. But if there is a scenario where you could retain somebody to do work off-site in some type of a consulting arrangement, that person would be more likely to be an independent contractor than an employee. A fourth factor is the duration of the relationship between the parties. If you're entering into this relationship with the worker for a limited amount of time, something that lasts for only a few months, it's more likely the case that the person is an independent contractor. However, if your relationship with this worker lasts for several years, for long periods of time, it's more likely the case that this particular worker is an employee. Another factor, whether the hiring partner has the right to assign additional projects to the hired party. If as the organization you have the right to continue to give assignments to this particular worker after he or she has completed one assignment, it's more likely the case that this particular worker is an employee and not an independent contractor. On the other hand, if you're just hiring this person to do a single job, they do the job and then the relationship is done, then it's more likely that the person's an independent contractor. Another factor is the extent of the hired party's discretion over when and how long to work. If you're making this worker come in every day from 8 to 5, promptly at 8, leaving promptly at 5, and clocking out for half an hour for a lunch, and no more, no less, then it's more likely that this particular person is being treated by you as an employee. On the other hand, if the worker has the discretion to come and go as he or she pleases without anybody telling them that they need to be present at a particular time frame, that person is more likely an independent contractor. If you've ever had a contractor work on your house, you'll know that those contractors come and go as they please. You can tell them that we would like you ideally to come between the hours of 9 and 5, and you can hold them accountable for making sure that the work is done in a timely fashion. But if you have a contractor come to your house to do some project in your house, you can't tell them they have to be here at 9 and they have to leave at 5 or they're going to be fired. The same thing applies to your organization. If you have independent contractors, you have to allow them some flexibility in when they come into work. Moving on to slide 12, some other factors. The method of payment. If you're paying the worker a regular wage based on an hour or on the day or on the week, it's more likely the case that that particular worker is an employee. On the other hand, if you're paying the worker based on the job or on a commission basis, that would appear to be more of an independent contractor relationship. Another factor is the hired party's role in hiring and paying assistants. Typically, employees don't have employees of their own. They might have people that they supervise, but the individuals they supervise are not their employees. That's not the case with independent contractors. Independent contractors can hire subcontractors, or they can hire employees to work for them to get done the work that you are contracting with them to perform. Another factor, whether the work is part of the regular business of the hiring party. If you are hiring somebody to do work that is part of the essential function that your organization performs, then it's more likely the case that that person is an employee than an independent contractor. Conversely, if you're hiring somebody to do some type of a specialized job that is different from the main function of your organization, there's a much greater possibility that that person is an independent contractor. Another factor, whether the hiring party is in business. In the scenario that your organization is going to face as a nonprofit, typically you're always going to be in business, even if you're a nonprofit organization. But returning to the initial scenario that I talked about, when you hire somebody to do work on your house, if you have a contractor coming in to renovate at your house, nobody's going to think that you are that contractor's employer, in part because as an individual private citizen, you're not in business. Not so with a case of organizations and corporations. If you are in business, that's just one more factor that would seem to suggest that the worker is an employee and not an independent contractor. Another factor is the provision of employee benefits. If you are providing benefits to your independent contractors that are similar or the same as the benefits that you're providing to your employees, it would look much more like these people are actually employees and not independent contractors. And a final factor is the tax treatment of the hired party. If you are withholding for taxes from their earnings, if you're reporting their earnings on a W-2, you are treating them as an employee. On the other hand, if you're not withholding taxes from their earnings and you're reporting their earnings on a 1099, you're treating them like an independent contractor. Now, I should note that not any one of these factors is going to be dispositive of the issue of whether a worker is an independent contractor or an employee. You have to look at all these factors, and it might very well be the case that some of the factors are going to suggest employee status, and other factors are going to suggest independent contractor status. And there's not going to be a simple answer as to whether the workers are employees or independent contractors. You're going to have to balance out all these factors to determine whether the workers should be classified as an employee or as an independent contractor. I should note that some laws provide a more specific definition of the term employee than would be provided by this common law test. Some statutes actually define in a very helpful way the term employee so that you know with a little more clarity what is actually going to be considered an employee. If a worker is an employee under a particular statutory definition, that worker is known as a statutory employee. And a worker can be a statutory employee for purposes of one particular law, even if that worker would be an independent contractor under the common law test. There are very few examples of these in the law, but one of the most important examples that you should be familiar with if you are an organization in Georgia is the Georgia Employment Security Law. I mentioned earlier that if your employees lose their employment, generally they're going to be eligible to receive unemployment compensation benefits. And under Georgia law, you have to pay taxes on the wages of your employees that go into this fund to pay unemployment compensation benefits. Under the statute in Georgia, a worker is presumed to be an employee unless the individual has been and will continue to be free from control or direction over the performance of their services, both under the individual's contract and in fact, and that individual is, quote, customarily engaged in an independently established trade, occupation, profession, or business. That's one way they can be an independent contractor. The other way is that there's been actually a determination made by the Internal Revenue Service that this person is an independent contractor and not an employee. This is a much harder standard to meet for independent contractor status than the common law test, because you have to show not only that the person is free from your control, but also that they are engaged in an independently established trade or profession. It can be the case that workers that you have working for your organization might be independent contractors under the common law test with respect to a number of different laws, but need to be treated as statutory employees under the Georgia Unemployment Compensation Statute.
So then does that mean that if you're choosing between the two, do you just treat them as an employee all the time? Or do you treat them as an employee some of the time for that law and then also as an independent contractor?
The safest bet would be to treat them as an employee all the time if you determine that you cannot treat them as an independent contractor under the Georgia statute. That said, if you have a strong or at least reasonable argument that these people are in fact independent contractors under the common law test, you could reasonably treat them as independent contractors with respect to other laws, but treat them as an employee for purposes of the unemployment compensation statute. But you just want to make sure that in doing so, you are making the distinction clear to the employee or to the worker, and also that that you really do have good grounds for treating them as an independent contractor under the common law test. I mentioned that there can be significant exposure to your organization if you misclassify workers as independent contractors when they really should be employees. And slide 14 lists some of the areas that your organization could face exposure. The first is that you could be liable under the Fair Labor Standards Act to pay minimum wages and overtime. As I mentioned before, this is a statute that applies to employees but not to independent contractors. And unless the worker is exempt from the requirements of the FLSA, if it's determined that they are in fact an employee, you need to pay them overtime anytime they work more than 40 hours in a single work week. So there could be that exposure. Under the statute, there's a period of 2 years that the employee could recover unpaid wages under the statute, or a period of 3 years if they can show that there was a willful violation of the statute. And in some cases, misclassifying a worker as an independent contractor when they should be an employee could be deemed a willful violation.
If you think that an employer is violating the rules, what is the best way to confidentially report the employer?
I think the question is asking as a worker, if you think that the organization is violating rules about classification, what's the best way that you can confidentially report the worker? Well, to some extent, it's going to depend on what statute is implicated here, but workers do have the right to bring a complaint with the Department of Labor if they feel that they are improperly classified as being independent contractors when in fact they're employees. Yes.
Would it be an appropriate approach to try and talk to the employer first?
And that exactly is correct. If you feel that you are an independent actually an employee and you've been classified as an independent contractor, it would be appropriate to first address that with your employer or the company that you're doing business with, to first figure out whether you're on the same page with the employer and not have to have any other additional steps taken. In addition to the exposure that your organization could have for payment of back wages, you could also be subject to an audit by the Department of Labor if you have workers that are misclassified as being independent contractors when actually they're employees. Another area of potential exposure to your organization is liability for back taxes and penalties under state and federal tax laws. As I mentioned before, if your workers are employees, you're required to withhold taxes from their earnings and also to pay an employee portion of taxes based on the wages that you're paying to the employees. If you have not done that because you've misclassified your workers as independent contractors, there can be some exposure under state and federal tax laws. A third area of exposure is loss of protection of the workers' compensation statutes. Every state has a workers' compensation statute that provides that if an employee is injured on the job, that there is a method for getting a payment, basically through an insurance program, to that employee to allow that employee to recover for his or her injuries. Independent contractors are not subject to that insurance regime, and so they would not be able to make a claim under the workers' compensation statute. However, if they're injured on the job, they could then sue your organization without any limitation in the damages that they can recover. So although the workers' compensation statute requires you to pay some money into this fund, it also provides you protection if your workers are actually employees. Yes.
If not employees, is it a good idea to have a contract that might address those issues?
Absolutely, and we're going to talk a little bit about some things you can do to protect yourself as an organization when you have independent contractors. But one of the things that you would want to do as an organization is require independent contractors to show proof of insurance, to show that there is some type of remedy that they could get beyond having to sue you in court to recover for any damages that they suffer as a result of the work relationship. Another potential area of exposure for your organization, if you're misclassifying your workers as independent contractors, is under ERISA. ERISA is a federal statute that governs employee benefits. There's not usually any requirement that you provide particular paid benefits to your employees. However, if you do have employee benefits, you need to generally make sure that all your employees are participating in those plans. If you have workers that you've misclassified as independent contractors who are not eligible to participate in the plans because of their misclassification, you could see some exposure under ERISA to those particular workers. We talked earlier about the first case study regarding Tim that was on slide 6. Tim, you'll remember, was the guy who did seminars for a nonprofit, and this nonprofit paid him a stipend. Tim argued that he was an employee and should have gotten overtime wages and should have gotten employee benefits. The nonprofit said, no, you're not an employee, you're an independent contractor. You're not eligible for those types of benefits and overtime wages. This case study actually comes from a case that was decided by a federal court in Kansas in 2004 called Mueller versus American Management Association International. This is on slide 15. This was a nonprofit that hired not just Tim, but a number of other professionals in the community to do a series of seminars for the organization. And in the case of Tim, he had provided these seminars on a regular basis, the course of several years, argued that given the longevity of his relationship with this organization, he was really their employee and not an independent contractor. Fortunately for the nonprofit, the court sided with the nonprofit and said that he was in fact an independent contractor, at least with respect to ERISA. They really punted the issue on whether he was an employee under the Fair Labor Standards Act. They determined that even if he was an employee and not an independent contractor, he was exempt from the overtime requirements of the statute, and that's something that we'll talk about next month in the Employment 102 webinar. But it's important to note, I think, in this case, that this particular worker, Tim, was an independent contractor under ERISA and maybe the FLSA, even though the state of Kansas had already determined that he was an employee for purposes of the Kansas Unemployment Security Statute, which is similar to Georgia's. And so here's an example of somebody who can be a statutory employee under one statute, but a common law independent contractor under other statutes. Just a few other things to note about the case. In this particular case, Tim had a written employment agreement with a written contract with the nonprofit, clearly specifying that he was an independent contractor, not an employee. And that was a big factor that the court looked at in determining that he really was an independent contractor. The court didn't go into this in any detail, but I think it's interesting to note as well that the type of services he was providing really did require some special area of knowledge, and that, I think, is probably one of the other factors that made the court determine that he was an independent contractor, not an employee, even though the court didn't expressly say that. Well, what are some ways that you can protect your organization if you have workers that are independent contractors and you think that they are properly classified as such?
I'm sorry,
Yes.
before you go into that,
Sure.
I guess I'm still confused. So if, in this case, would they then have to go back and treat him as an employee or only for state workers' compensation
Yeah,
purposes?
right.
Can you just pay into that and then treat him as an independent contractor otherwise? I'm not sure how you ultimately deal with that person.
Right. Well, in this particular situation, it was a scenario where the state had determined that this guy was an employee for purposes of state unemployment compensation. and the nonprofit had had then from that point on treated him as an employee with respect to that one statute, and they were paying unemployment compensation taxes on his wages. They were treating him as an independent contractor with respect to all the other statutes. Perhaps the conservative option for the organization at this point would have been, once the state determined he was an independent contractor under the state unemployment compensation regime, to just treat him consistently as an independent contractor under all statutes. It probably would have saved them a lawsuit down the road. That's not what they chose to do here.
Do you mean employee or independent? I'm confused.
I'm sorry. Yeah, treat them as
complicated.
I'm sorry. Yes, to treat them consistently as an employee with respect to all the other statutes.
That's very helpful, thank you.
Sure. Sorry about that misstatement there. One of the important things that you should do if you have independent contractors that you believe are properly classified as such is to have a written independent contractor agreement with them. But be careful about the language you use in there. When you are referring to the parties in the contract, you should refer to the worker as a contractor, a consultant, an agent. Don't refer to the worker as an employee, and don't refer to your organization as an employer. If you're going to have this type of an agreement, which is recommended, you want to make sure that the language you use in the agreement represents what your intent is, and that you're not just cutting and pasting language that you would use in an employment contract. The agreement should expressly say that the parties intend to enter into an independent contractor relationship and not into any kind of employment relationship. The contract should clearly specify what the contractor's authorities and duties and responsibilities are, and to the extent possible, it should give as much discretion to the contractor in the means and method by which he or she is performing the work, as opposed to an employee relationship where you are reserving the right to control how that worker does his or her job. The contract should specify what the mode of payment is going to be. To the extent feasible, it's great to be able to pay an independent contractor on a project or commission basis and not based on an hourly, monthly, or weekly wage or salary. The contract should say who's responsible for taxes, and in this case, for an independent contractor. It should say clearly that the independent contractor is going to be responsible for paying any taxes that he's obligated to pay under tax laws, and that the company, the organization, is not going to withhold taxes from the earnings. It should also specify what can happen on the termination of the contract. Usually it should say that either party can terminate the contract with or without notice, and it should specify what the rights of the various parties are if the contract is terminated. For example, if you've hired this contractor to do a job and the job hasn't been done yet, what are your rights as an organization? With apologies to Robin Williams and John Lennon, another thing you can do is don't seize the day, but let it be. When you're dealing with employees, you typically want to closely manage how they're doing their job. Not so with independent contractors, and you want to not bring the same mindset into an independent contractor relationship as you would with respect to your employees. The contractor should set the starting and quitting times. As an organization, you should not demand that the contractor show up at a certain time every day, work a steady 8 hours, and then leave at the end of the day. The location of the work is another area. If feasible, for example, if you have a consultant who can perform work at some other location of their choice, it's great in your independent contractor relationship if you can allow the independent contractor to choose where they're going to do the work. That's not going to be feasible a lot of times. You're going to actually need them to be on your premises. But if you can avoid that, that's ideal. Equipment. The contractor should provide his or her equipment to the extent feasible. Employees. The contractor is free to hire subcontractors or employees to do the job that you're contracting with that person to do. Expenses. Operating expenses should be borne by the independent contractor. It's okay to agree to reimburse that contractor some expenses, but you want to clarify at the beginning what those expenses are going to be that you're going to reimburse them for. Benefits. Typically, independent contractors don't receive benefits, and so generally you should not be providing the same types of benefits to independent contractors that you're providing to your employees. And that goes with respect to things like group health care plans, but also things like paid vacation time. Exclusivity. It's preferable not to have an agreement where you are requiring the independent contractor to serve your organization exclusively. They should be free to do other work for other organizations as long as it doesn't conflict with their obligations to your organization. Let's move on to the second threshold question now. Are your volunteers really volunteers, or are they employees? There's no broad statutory exception for volunteers in the private sector under the Fair Labor Standards Act. In the for-profit private sector, all work must be paid work. There are some exceptions that have been provided. For example, the FLSA has a big exception for organizations in the public sector. There's also a very narrow exception to the statute for workers who volunteer to help out with food banks. Other than that, there's nothing that's actually set out in the statute in the FLSA that provides an exception for volunteers in the private sector. However, fortunately, the Supreme Court and the Department of Labor have both recognized an exception for people who are volunteering in the not-for-profit sector of the private sector. The Supreme Court's exception in their terminology is that an individual who, quote, without promise or expectation of compensation, but solely for his personal purpose or pleasure, worked in activities carried on by other persons either for their pleasure or profit, is outside the sweep of the FLSA. And the Department of Labor has a test that they use to determine whether somebody really has volunteered their time or whether they're actually an employee in disguise. The Department of Labor considers at least three factors, which are on slide 19. They consider the receipt of any benefits from those for whom the services are performed, whether the activity is a less than full-time occupation, and whether the services are of the kind typically associated with volunteer work. Having somebody who comes in to your organization for a few hours a week and helps out with teaching reading to children or something else like that, that's a typical activity a volunteer would be expected to do and is not full-time, is more likely to be a volunteer. It can be much more complicated in a situation where you have somebody who is volunteering the equivalent of a full week's work and doing the type of work that one would not typically associate with volunteer activities. For example, in slide 18, the Supreme Court test that I talked about a minute ago was developed by the Supreme Court in a case called Tony and Susan Alamo Foundation versus Secretary of Labor. That was a 1985 case. That was a case where a religious nonprofit, which was called the Tony and Susan Alamo Foundation, operated a number of commercial establishments that they used to help fund their ministry. They had a few hotels they ran, some gas stations. I think they had a hog farm. And what they would do is they would have individuals who were receiving services by this organization, most of whom were recovering drug users or people who had recently gotten out of prison. And these individuals were working at these commercial establishments. In exchange, the Tony and Susan Alamo Foundation was providing shelter to these people, clothing, food, just a means to get by while these people were getting back on their feet. The individuals who were receiving these services and working in the commercial establishments testified that they didn't expect any compensation at all. They were just grateful that this organization was helping them out. But the government saw things differently, and in this case, the Supreme Court said that notwithstanding the fact that these people had said that they didn't expect to get any compensation, they were not volunteers but were employees under the FLSA, and so the organization was required to pay them overtime wages. Now, this is a very unusual factual scenario, since most times nonprofits are not going to have these kind of side commercial activities. But it's an important distinction to note here that there can be cases where individuals who you think are properly volunteers could in some situations be employees, and the Supreme Court noted here that these individuals were entirely dependent upon the foundation for long periods of time, sometimes many years. And so that was a situation in this case that led the court to conclude that these people were employees. That brings us to our case study number 2 about Marcy. Marcy, you'll recall, was somebody who volunteered to do grant writing for an organization. The grant was approved, and then she was hired by the organization to do some teaching as well, teaching classes on parenting. She then sued the organization, saying that she should be paid not just for the time she spent doing the teaching the parenting classes, but also for the time that she spent doing the grant writing. Is she a volunteer with respect to the grant writing work? Well, a federal court in Louisiana said that she may be not a volunteer. In that case, the nonprofit asked the court to dismiss the case before it could go to a jury, saying that this person had no expectation of compensation. She was a volunteer with respect to this activity. The worker alleged that the director told her to, quote, bill her for the hours she spent writing the grants, and so the court said, even though she said in her deposition under oath that she didn't expect any compensation, there was a dispute about the facts here that could have reasonably suggested that she was actually an employee who was supposed to get paid for her time and not a volunteer. And so the court said, this is something we can't resolve. We're going to have to send this to the jury, and the jury is going to have to figure out who's telling the truth here. The lesson here is that you ought to try to avoid these ambiguous situations at the outset. In this case, if the organization had an agreement with this worker clearly specifying what activities she was agreeing to volunteer to do and that she wasn't going to get any compensation for that versus the things that she really was getting hired to do, they probably could have avoided a lawsuit down the road. Can your employees be employees with respect to some activities and volunteers with respect to other activities? This is probably going to be something relevant to your organization as a nonprofit, because often your employees may want to volunteer their time during their non-work hours because they're dedicated to the mission of your organization. This is laudable on the part of your workers, but you ought to be careful about allowing your employees to volunteer their time for your organization. The Department of Labor has a standard that they look at to determine if employees of nonprofits are volunteering their services or can volunteer their services. Under the Department of Labor standards, employees of nonprofits can only volunteer their services if the services that they volunteer are not the same type of service that the employees are employed to perform, and the services take place outside of the employee's normal working hours. And so you'll recall case study 3, Mike and Julie. Julie is a administrative assistant for a nonprofit that provides after-school activities for children. Mike, her husband, is a counselor to the children. The organization sponsors a trip to a baseball game, and they would like to chaperone to take the children to that on Saturday, which is their day off. Well, can they volunteer to do this activity without being paid? This is a scenario that the Department of Labor considered and addressed in an opinion letter that they sent to the nonprofit back in 2006. And the Department of Labor applied the test that I mentioned a minute ago, and the conclusion that they reached is that if the employee's regular duties involve work similar to chaperoning, then the employee may not volunteer. For example, a secretary may volunteer to chaperone a trip, but a counselor whose regular duties involve supervising the children may not volunteer to chaperone a trip. And so, as odd as it may seem in this situation, the outcome, at least as the Department of Labor would have it, is that Julie, the administrative assistant, can volunteer to take these children to the baseball game on a Saturday, because this is different from the type of work that she normally performs, and it's not during her normal work day. On the other hand, the organization would probably have to pay her husband Mike for the time that he spends chaperoning these these children to this baseball game because it's the same type of work that he normally does during the week. So that's the outcome, at least that the Department of Labor would advocate in that particular situation. Yes?
One viewer is asking are you suggesting that a nonprofit writes an agreement with a volunteer that they're going to perform X amount of hours or to do certain work as a volunteer?
Yeah, actually that is something I'm recommending, and that actually brings us to slide 23, which is practice pointers. To the extent it's feasible, it would be preferable to require some type of acknowledgement on the part of the volunteer that they are a volunteer. Now, I'm not saying that you need to have an acknowledgement where they're going to agree that they're going to work X number of hours, but you ought to have some type of acknowledgement, if feasible, that the worker is volunteering their time. They don't have any expectation of compensation for their time. A lot of times, nonprofits will have an application that potential volunteers are required to fill out. I know here in Atlanta, any charitable organizations that are associated with the Catholic Archdiocese of Atlanta have a very extensive application process with background checks. If you're requiring potential volunteers to fill out those kind of forms anyway, it would be convenient in that form to just put some type of acknowledgement that the volunteer acknowledges that they are actually volunteering the services and that there's not any type of compensation they're going to get. Yes?
In doing these kinds of agreements, it still has to be that the work that they're performing is totally different from their regular work.
That's exactly right. Just because you have this agreement doesn't going to mean that you can then have your employees of your nonprofit volunteer all sorts of activities that are similar to the work that they're doing. If you're dealing with individuals who are your employees already and they want to volunteer activities as opposed to somebody who is purely a volunteer, you will want to specify which activities they're doing are volunteer activities. But again, if these are activities that are similar to the type of work that they normally do and are normal during their normal work hours, you're not going to be able to get around the issue of volunteer versus employee status by this agreement. You're going to have to pay them for their time if it's work similar to the type of work they perform for you for a paid basis, or if it's work done during their regular work hours. Another practice pointer in dealing with your volunteers is to be mindful of any gifts that you provide your volunteers. A lot of nonprofits like to provide thank you gifts to their volunteers, just to thank them for the time that they've spent to help out the organization. And there's nothing wrong with this, but you should be careful to make sure that the gifts that you're giving your volunteers are of a minimal value. Things like T-shirts or a gift card of a very small value. These are appropriate gifts. If you start to give gifts that are worth a lot of money, it's going to look more like these people are volunteering their time with the expectation that they're going to get something in return, which would suggest that they're not actually volunteers, but they are people who are working for compensation. Final point is just be mindful of employees volunteering their time for activities sponsored by your organization. As I mentioned a minute ago, you have to be careful that your employees, if they are volunteering their time, are not doing activities that are similar or identical to the types of things that they are getting paid for, and they're not doing volunteer activities during their normal work hours. In addition to that, I think it's always prudent, to the extent you can do this, to have something in writing clarifying that the activities that this employee are doing off hours that are different from the normal work activities are volunteer activities for which they have no expectation of pay. Well, that brings us to, we have a question.
One viewer has a couple questions specific
Sure.
to situation. It says that there's a nonprofit operating a thrift store for the purpose of raising unrestricted revenue for its services. The first question is, should the nonprofit limit the number of hours offered to a volunteer?
Well, I can't I can't comment on any specific factual scenario because this is general information that I have to know a lot more information about a number of different factors in order to be able to provide an analysis of this. But I recommend that you get in contact with the Pro Bono Partnership of Atlanta, and they can help point you in the direction of a lawyer who can provide specific advice about this particular scenario. We've got a little more time before our hour's up here, and so if there are any other questions, let's go over those right now.
I think that's all that's come in.
Okay.
We're great. Thank you.
All right. Thank you so much.